Hi, welcome to Achievers Law Academy's YouTube channel. Today, we are going to learn another constitutional landmark judgment, and this case is a direct continuation of what we discussed earlier in Shankari Prasad and Sajjan Singh. If you have not watched our earlier videos, the link for the same is given in the description below. Please watch that video first and then come back here, because only then you will clearly understand why Golaknath became a constitutional turning point. A small recap. In Shankari Prasad, the Supreme Court clearly held that Parliament has the power to amend fundamental rights under Article 368. At that point, the court believed that constitutional amendments are not law under Article 13. But just 14 years later, the Supreme Court re-examined this position, and that re-examination gave birth to IC Golaknath vs. State of Punjab. Let us now understand the facts of Golaknath's case. The Golaknath family were landowners in Jalandhar district, Punjab. They owned more than 500 acres of agricultural land. In 1953, the Punjab government enacted a land reform law called the Punjab Security of Land Tenures Act 1953. This act imposed a ceiling on land ownership. Under this law, an individual could hold only 30 standard acres, which is approximately 60 ordinary acres. Any land beyond this limit was treated as surplus land, and the surplus land will be acquired by the state government. The objective of this legislation was land redistribution to promote social justice and improve agricultural productivity in post-independence India. The Golaknath family challenged this act before the Supreme Court. Their argument was very clear. They contended that the act violated their fundamental rights, namely Article 19(1)(f), the right to acquire, hold and dispose of property, and Article 31, protection against deprivation of property. They argued that the state cannot take away their property without violating this constitutional guarantee. Now comes the most important constitutional twist. To protect land reform laws from judicial challenge, Parliament enacted the 17th Constitutional Amendment Act in 1964. By this amendment, the Punjab Security of Land Tenures Act was placed in the 9th schedule of the Constitution. And you already know, once a law is placed in the 9th schedule, it becomes immune from judicial review, even if it violates fundamental rights. The Golaknath family therefore challenged the Punjab Act and the 17th Constitutional Amendment itself. This brought the case directly to the Supreme Court of India. The main constitutional question before the court was, first, can Parliament amend fundamental rights? Second, is a constitutional amendment law under Article 13? If the answer is yes, then Parliament cannot amend fundamental rights because Article 13 prohibits law that take away fundamental rights. This question shook the foundation of constitutional law in India. And here comes the turning point. In 1967, a bench of 11 judges delivered the historic judgment. By a narrow majority of 6:5, the Supreme Court held Parliament has no power to amend fundamental rights. The court ruled that constitutional amendments are law within the meaning of Article 13. Therefore, any amendment that violates fundamental rights is void. This judgment overruled Shankari Prasad and Sajjan Singh case. However, the court also adopted a new doctrine called the doctrine of Prospective Overruling. This means amendments made before Golaknath would remain valid, but from this judgment onwards, Parliament cannot amend fundamental rights. This doctrine was basically an American constitutional law doctrine and was used for the first time in India in Golaknath's case. The Golaknath judgment had far-reaching consequences. First, it strengthened judicial supremacy. Second, it placed fundamental rights above Parliament. Third, it created a constitutional deadlock between the Parliament and the Judiciary. The deadlock eventually led to 24th Constitutional Amendment and 25th Constitutional Amendment, and finally the historic Keshavananda Bharati case in 1973. So, Golaknath was not the end. It was only the beginning of a larger constitutional battle. From parliamentary supremacy to judicial supremacy, India was slowly moving towards the basic structure doctrine. And that story continues in our next video. Until then, keep learning, keep questioning, and keep preparing with us. Subscribe to Achievers Law Academy. Thank you.